briefing. I am aware of the prior litigation that involved the student who was one of, I think, 3 or 4 students who were disciplined in some manner by the school district. That was overturned by the state school board through the appellate process, and then I affirmed the state school board. And where we are now procedurally, as I understand it, is that the student, through the student's parent, has asked the court to issue a writ of mandamus ordering the school, which is a magnet school that has a lottery, like a merit/lottery admission program of some sort, to order them to let her back in, which they've declined to do. And I think I'm also here on a motion for summary judgment and a motion to dismiss that was filed by the school district, at least in part on the basis that they believe either issue preclusion or some sort of estoppel or res judicata argument precludes the position that the student's trying to take here. And I think that's what I understand us where we are now. This was originally set as the actual substantive hearing because my understanding of the statute is that a mandamus action needs to be set with all due haste. And so we did. And then the school district filed a motion for summary judgment, motion to dismiss. And so I think where we settled, Ms. Waldman filed an expedited response. And I think where we settled was that the idea for today was to at least work through the summary judgment and the motion to dismiss and figure out what it means for the larger picture today. So everybody in agreement? That's generally the outline, Mr. Bryan.
That's exactly right, Your Honor.
Okay, Ms. Waldman?
Yes, Your Honor.
Okay. So if that's the case, then why don't we start with Mr. Bryan on the motion to dismiss and the motion for summary judgment that you have filed, if you want to start with that. The only thing I will tell you is just because it's the beginning of the year, I'm being a real stickler for the rules, but I'll let you know that you filed a reply brief, which I have not read because my rules say that you have to ask permission to file a reply brief, and nobody asked me for permission. So just so you know, I don't know anything about what's in your reply brief.
That's fair enough, Your Honor. I do apologize for that. I know we did file a reply brief in the previous one, and now that you mention it, I do think we asked permission to do that first, so I apologize.
And to be clear, I try to make sure, it's not like I need you to file a motion or anything. You just email the court and say, hey, we want to file a reply, and usually it's fine. But it's not that you can't make those arguments now. I'm just telling you, I've read all the briefing. I've not read the reply. Go ahead, Mr. Bryan.
Fair enough, Your Honor, and thank you for clarifying that. But as you mentioned, we are here on the respondent's motion for summary judgment and motion to dismiss. Everyone is pretty familiar with the background facts here. So, I think I'll cut straight to the chase if that's okay with you, Your Honor. Do you want to get back into the facts of the previous case?
I feel like I recall the general outline of the previous case, and that to the extent we need to talk about the facts of that case, it should only be those particular facts that are specific to the outcome here, because I think we all sort of have a good idea of what it was. So
that's right, Your Honor. So I'll keep my little background chat brief here. Really, the only facts that we need to talk about is the facts that occurred during litigation. Right. I mean, the underlying facts are the same, but what happened is that the Fulton County Board of Education disciplined student SC, suspended her based on alleged, violations of the student code of conduct, and then barred her from attending Innovation Academy. SC, to her credit, successfully appealed that to the State Board of Education, and this court affirmed that there was no violation of the student code of conduct. Now, what's important is to discuss what happened during that litigation, what claims were raised, and what the impact is of the parties' different stances during that litigation. Of course, the doctrine of res judicata, it bars all claims that were or could have been raised in a previous case that was decided between the same parties or their privies that was decided on the merits by a court of competent jurisdiction. Now, I know that's a mouthful, Your Honor, and so the Georgia courts have sort of split that doctrine up into three different elements. One element is, did the previous case concern the same parties or their privies as the current case to understand whether preclusion doctrine would apply. And
well, let me save you some trouble.
Sure.
I think SC was the actual named party in the lower case, but clearly that person, who I'm assuming is still a minor's parent, has the right to assert claims on their behalf. So I don't think you have to persuade me that there's privity, that there is identity of parties in this action to the last one.
I agree, Your Honor. And as far as I can tell, the petitioners didn't challenge that in their response to the motion. So I will move on. The other two elements are, the identity of cause of action, or a lot of times courts refer to that as being the same claims, right? And then the third element is adjudication on the merits by a court of competent jurisdiction, which really is kind of two sub-elements: an adjudication on the merits by a court of competent jurisdiction. And hopefully
we all agree I'm a court of competent jurisdiction, right?
Yeah, yes, we do agree. Okay, that is our position that you are.
Right. It seems to me that really at the heart of it, that where we need to spend our time talking, to me, is a component of this identity of claim, and then the aspect of adjudication as to whether this particular component of relief that they seek here, of reinstatement to the school, was in fact before the court in the prior action, and that the court adjudicated those issues, or that they had the right to raise those. That's sort of what I understand, is that's really where we need to spend our time talking. Do you agree, Mr. Bryan?
I agree. And do you prefer which one of those elements you want me to start with?
I do not.
Okay, let's go with the court of competent jurisdiction issue. Okay, what this element, requires is that the court that in the previous case had subject matter jurisdiction over the claims that were raised in that case, right? So long as the court had subject matter jurisdiction, then it was competent for purposes of res judicata. All right. And subject matter jurisdiction means whether the court has jurisdiction to consider the class of cases to which a particular claim belongs, right? So we're talking here that, does this court have subject matter jurisdiction to hear damages claims? Of course of course the Superior Court does. Does it have a subject matter jurisdiction to hear mandamus claims, to hear, to decide whether a constitutional provision was violated, these kind of things? Does a court have subject matter jurisdiction to consider the claims that were raised before it? Now,
well, given that my understanding of the statutory structure for appeals of this nature, even under the new statutory structure, is that the appropriate redress upon to request review of a decision by the State Board of Education is the Superior Court of the county, in the county where that board is. And so, I guess, to me, the issue is not whether I was empowered to hear this case generally, but that part of the discussion in that prior case was whether I had the authority in that case, or Ms. Waldman had the ability to ask me in that case to order the school to re-enroll SC. And not, clearly I'm empowered to do that as a general proposition. As a Superior Court judge, I have the authority to order equity and to enter restraining orders and or injunctive relief and or mandamus. But nobody disputes, I think, that wasn't what I was being asked in that case. I was only being asked to consider, to review the decision of the State Board of Education, which is what I did.
I would respectfully disagree with that, Your Honor. SC did ask this court to reinstate her to Innovation Academy. She asked for that affirmative relief 4 times. Once in a motion, the emergency motion. Second, during the emergency hearing. Third, in her merits brief, asked the court to order SC back to Innovation Academy. And then again in the final hearing over, several times. And so 4 times SC asked this court to decide whether she was entitled to return to Innovation Academy, and then she specifically asked this court to do so. And that's not in dispute. I mean, that's just a matter of fact. All of those facts are in the record. What SC asked you to do is in the record.
Right. To clarify what I meant, I mean, I certainly understand that. And I think my recollection is when we discussed it was that I had questions as to whether I was empowered to take that step in the context of an appellate review case. I believe that was what my reservation was. It wasn't that I questioned that I'd been asked. I meant more that case was a petition for review of a decision by a lower administrative agency and not a mandamus action. And I don't know the answer to the question of whether, number one, a mandamus could have been coupled with it, or if I had the authority to do it, or if, to I think some of the briefing by Ms. Waldman's point, is if I said that the school was wrong, did not have the sufficient basis to discipline the student, SC, then I think Ms. Waldman's argument is the logical extension of that is, well, if part of the discipline was removing them from the school, they need to be restored to the school regardless of any action taken by the court. And that the fact that the school has declined to do that is why Ms. Waldman undertook the mandamus action now, to order them to do something she thinks they're required to do already without me ordering them to do so in the prior action.
Well, Your Honor, that was a lot there.
It was, I know.
So let me go ahead and see if I can, break it down into its component parts here, and hopefully I'll address everything that you've asked me to. And if I don't, please ask again if I missed anything. So the first question is, okay, everyone agrees that, this claim was raised, the claim to asking you to order SC back to Innovation Academy. We all agree that was raised 4 times. So the next question I think that you asked is, did you have authority under OCGA 221160 through that appeal statute to issue that relief? Right. And then you said, well, could a mandamus have been coupled with that? And therefore, how does that impact the res judicata analysis? So I'm going to start with that. All right. First, I think we can immediately go. I think the easiest way to resolve that is to look at the Henry County Board of Education versus SG case, which is 301 Georgia 74. It's that 2017 student discipline case. You'll notice that in that case, the student, just like SC did during her appeal, not only raised a statutory discipline appeal claim, right, saying, hey, look, we want to challenge this. We want to challenge this discipline. They also asked the court. They also included a separate claim asking the court to expunge the record. Now, none of these appeal statutes say anything about expunging a record, right? But they still raise that equitable claim along with the statutory appeal. Anyway, so to your point about coupling, we have one case that's right on point. It says even in student disciplinary appeals, obviously people are allowed to raise other claims outside of that appeal. Of course, now don't get me wrong, whether that claim is meritorious is a completely different issue, right? But we're talking about whether parties have the power or are authorized, so to speak, to raise a claim and whether the court is authorized to rule on it. So we know that the Georgia Supreme Court at least thinks that you can raise claims that are not specifically listed in 221160 because they allowed the student to do that in SG. That
Can
is
you forgive me, sorry, Mr. Brown, can you give me that site again? Because 301 Georgia 74 takes me to an in re matter of Lee case, which is a state bar case, which may also be relevant for some issue. But it's not pulling up.
it's not. That must be a typo. Let me go
No
ahead.
worries. But
Let me
you're directing me to a Henry County case, Henry County Board of Education. So I just
Yes, it's 301 Georgia 794. I don't know what I told you, but if I told you something else,
no, you told me 74. It's an easy typo. It looks like, and it just so happens to pull up an actual case.
got it.
As
Okay.
opposed to taking me somewhere in the nowhere land, which we all know sometimes they do when we get typos wrong. Go ahead. I have it now.
So if you look, all right, if you pull it up, if you go down to footnote 1 in that case, you'll see it says attorneys for the parties represent that SG attended the alternative school and graduated. Obviously, what happened here is that in this case, the school district must have wanted the appeal dismissed as moot because the student had graduated and therefore the discipline issue was was moot, and they wanted the whole case to go away. The Georgia Supreme Court said no, you can't because there's still an active claim. Case is not moot since SG seeks expungement of the expulsion from her school records, right? So that right there is a request for relief, a claim that falls outside the appeal statute. None of the appeal statutes say anything about that. So it falls outside of that statute. So right there, that's the first indication that the failure of an appeal statute to specifically list exactly which claims can be raised does not preclude a party from raising them, and it doesn't preclude a court from considering it. Because if that claim was no longer was invalid, then it would have been just the whole thing would have been dismissed as moot. Obviously, that claim was very important and it was colorable. Otherwise, the appeal would have been dismissed. So there's one clue that that this court would have had authority to entertain a claim like that. A second one is, this may be something that you're familiar with in another context, but it's not unusual for folks to raise, different types of claims alongside statutory appeals. So, for example, we have the Camera Real Estate Holdings versus Forsyth County Board of Commissioners. I hope I get the site right this time. 302 Georgia 284. You can go through that case, and in that case, what happened is that a property owner applied for a rezoning, or at least a change of a zoning condition, was denied. So he appealed that via the petition for writ of cert process, right? But then also on top of that, he added a bunch of other claims, including a claim saying, please issue the building permit that would come along with, that would have been authorized had you, properly adjudicated the zoning claim. And so, there's another one showing in a statutory appeal process from the writ of cert process. The court allowed, in fact, actually, the trial court dismissed those claims, and the Georgia Supreme Court reversed, saying you shouldn't have dismissed them. So, there's obviously some authority for the idea that these claims can be brought in conjunction with each other. Also, there is no limiting language in 22-1160. There's no limiting language. It saying that you can't raise any other claims. Now, of course, the appeal claim itself is limited to the remedies that are in there. Of course, the appeal claim itself must comply and is limited by the claims and remedies authorized by that. But that doesn't mean that it blocks all other claims. And here's a good. I'm sorry, Your Honor.
No, go ahead.
Say that there's actually a case that is damn near on point about this too, in terms of the res judicata issue, and that is McCracken versus the city of College Park. Let me go ahead and see if I can pull that one up real quick here. I'm sorry, I have several different tabs open right now, but the McCracken versus the city of College Park is 259 GA 490. All right, this is a res judicata case. In that case, which again is very similar to ours in the sense the procedural elements of it. In that case, a plaintiff, or the city of College Park revoked a liquor license, right? And the licensee, they appealed that decision through the petition for writ of cert process, the old petition for review process. They appealed that to the Superior Court. And the Superior Court, ended up dismissing that claim, did not, on the merits, boom, done. So what they do is they file a new action, an equitable action, seeking declaratory and injunctive relief, raising, more or less the same claims that were raised in the, statutory appeal process. And
let, let me ask you this, Mr. Bryant. So what I'm wondering though is in terms of the issue of res judicata typically turns on whether or not it was something that could have been raised or something that had to have been raised.
Or was raised.
Right. Well, was raised. And if it wasn't raised, either could have been raised, and that seems to be the difference. If it could have been raised versus if it had to have been raised. And I guess one thing this is a similarity that may be distinguishable, but one of the things I'm reminded of in this context though is indemnity claims, right? People typically raise indemnity claims in the original answer or an original action, even though technically that indemnity claim has not yet been perfected and does not yet exist until someone finds that entity liable or responsible, and then you can take that finding and then go and assert a claim. And one of the things I'm wondering is if there's an argument to be made here that even if SC asked for that relief, that the basis for the relief didn't actually exist in the prior action, because as I think I understand Ms. Waldman's going to tell me I'm wrong in just a minute probably, but that if the basis for discipline is removed, then the expectation was, regardless of any order by the court, that the student would have been returned to the school because there was no basis for her to have been removed from it. And only when they were told that she would not be allowed to return did the mandamus become ripe, right? The cause of action at that point accrued.
Okay, so so really you're asking, did this claim to return to Innovation Academy only accrue after final judgment in the prior case?
Right.
Okay, got it. I don't think that that's true at all, because the claim would have accrued, right, based on the underlying facts of being denied enrollment at Innovation Academy. If the basis of the claim is illegal discipline, improper denial of entry, right? Both of those existed before final judgment. And again, that is actually in the pleadings in the appeal. Both A, saying that, hey, she was illegally disciplined and therefore has been illegally barred from Innovation Academy. That was raised in the emergency motion. And again, it was raised in the merits. All right. So no, this claim did not accrue after final judgment. This is more like, this is more like the McCracken case where okay, I guess the alternative argument would have been, hey, in McCracken, we didn't know for sure whether my claim for some equitable and declaratory relief didn't accrue in McCracken until after the Superior Court had already decided that after the decision to revoke the liquor license was finally decided, right? And that same logic applies here, right? The claim accrued. Her right to attend Innovation Academy, if in fact her right to attend Innovation Academy arises from the fact that the discipline imposed on her was illegal, that claim accrued long ago. That claim accrued when they initially expelled her in the first place. And so, I think that we start. I think a better way to view it is like a due process claim. When there is an element of a claim that necessarily cannot arise unless and until there's a final judgment, for example, in your indemnity claim or in a procedural due process claim, the judgment itself is an element of the new claim. And
Right.
that's not the case here. This judgment or this right depends on a finding that the discipline was illegal. That's already done. We're not deciding whether the discipline was correct anymore, because those are all those facts are together. They accrued together and the claim accrued together, which is why the claim was raised, in the previous action in the first place. And so, no, I do not think that this claim accrued after final judgment at all. Otherwise, what we could say is, all right, so let's just say this court, dismisses this action. What if she applies to Innovation Academy again? Is that a new claim now? What if she files another writ of mandamus? Does that a new claim now? Right? In other words, you can't keep creating a new claim every time you reapply for admission to a school. Someone that wants a liquor license doesn't have a new claim every single time that their liquor license application is denied. Otherwise, res judicata would be meaningless. There would be no end to the litigation under that view of the law. And again, it's more like a personal injury plaintiff who says, "Hey, look, how could I have known that I would have been entitled to damages until a court first determined that the defendant was liable in the first place?" Right? When you have a claim for relief that arises out of a particular cause of action, in this case, an illegal expulsion, right? You have to include all of your claims for relief in the first action. There's no claim splitting here, right? I mean, so what would happen now? Would she be able to now come back and ask for damages arising from the illegal discipline? No, of course not. She had that opportunity already, and that's all that res juda requires is a full and fair opportunity to raise claims for relief. And there is no question that that she had a full and fair opportunity to do it, because she did raise that claim. Now I get it. Now they kind of regret raising that because we got this preclusion bar to get over. But it's done. I mean, res judicata applies to claims that were actually raised. Now, the petitioners cite in their brief a case called Setlock versus Setlock. And they cite that for the proposition that, right, like, no. Just because you raise a claim does not mean that res judicata bars it, right? Because in Setlock versus Setlock, these counterclaim defendants were in magistrate court, and they raised declaratory and injunctive relief claims in magistrate court. Now, of course, magistrate court has no subject matter jurisdiction to issue that kind of relief or to decide those kind of claims in the first place. So the Georgia Supreme Court said, it's true that they raised these counterclaims for equitable and declaratory relief in magistrate court, but they're not barred from doing that again in superior court, because the magistrate court never had subject matter jurisdiction to consider those claims in the first place. Only the superior court had subject matter jurisdiction to hear those claims.
Right. Although the inverse is interestingly not true, which is that if you fail to raise those things in magistrate court, even though the court lacks jurisdiction, you are barred in superior court from raising those issues.
It's true. It's true. But of course, that also has to do with the funky magistrate court rules that require you to raise counterclaims, even if the magistrate court actually, lacks jurisdiction over them. But either way, the point being is that's the only case that has been brought to my attention, or that I've been able to find, where a party actually raised the claim and res judicata did not apply to it. right? And that's only because that was only in magistrate court. Actually, there may have been another one in juvenile court, but either way, that happened in lower courts. I can't find any case where they raised claims in superior court and then found out later that res judicata did not bar it. I can't
Well,
find any claim like that because and it makes sense that there wouldn't be, Your Honor, because the superior court is a court of really broad jurisdiction. Y'all really get to hear, you have original jurisdiction to hear most types of cases. And
let me
so I
ask
think
you, I want to go back to an example you gave a moment ago about zoning appeals or liquor license appeals. Um, and you made a comment about, the sort of serial filing of these things. Does that give rise to a new cause of action? And I guess I don't want to, because we're still sort of at this preliminary motion to dismiss slash motion for summary judgment stage, I don't want to get too far into the merits of it. But one thing that is unclear to me is what is the basis for the school districts declining to allow SC to enroll? And the reason I ask that question in the context of your references to, an application for a liquor license or whatever, or a zoning license is if I apply for a liquor license and I am told no because, right? And then I go fix those things and I apply and I'm told no because new things, then there is a universe in which that constitutes a new action. And so I'm just wondering, is part of the issue here that perhaps I don't have a fulsome understanding of what is the school districts or the schools stated basis for declining to allow SC's admission? Is it because of the prior discipline that this court said was not proper, or is it because she's not satisfied the requirements for admission? And I guess my question is, if it's because of that she's some new, okay, we've accepted your application, we've looked at it, and you don't qualify or you didn't get a lottery position or whatever, then isn't that a whole new issue?
Okay, to the extent you're suggesting, Your Honor, that well, okay, let me take a step back real quick. Right, that does go to the merits of the claim,
Right.
and we have neither party has submitted evidence, to that we actually moved.
Right.
That's
And
one
again,
ground
I, I
summary
didn't
judgment.
want to get too far into the merits, but the reason I bring it up is I do feel like the stated basis for decline, because I mean, at the end of the day, this is a mandamus action where SC is seeking to require the school to allow her admission. And so it does matter for substantive reasons at the merit stage why she was declined admission. But here it matters a little bit to me because if the stated basis is not an outgrowth of the prior discipline, then how could it be barred by res judicata? That's the only issue that I'm struggling with. Not that I want to get down to the weeds of who's more credible and was it proper and anything else like that.
Oh, I understand, Your Honor. Okay, and to the extent that, all right, so the letter that she received said Innovation Academy is at maximum capacity.
Okay.
All right. It was not based on the discipline. Not. We agree, or there is no question about that. Of course, we don't have any evidence in the record right now about it, but
Of course.
we are not taking the position that she is not able to attend because of those past alleged violations of the code of conduct. So now let's go ahead and think about what the implications of that are, Your Honor. All right. So if that's not the reason, then okay. So if it was the reason, all right, or I should say, um, if the basis of the claim for SC's entitlement to return to Innovation Academy is the illegal discipline, right? Then that claim would still be barred because it is the same claim as the claim that was raised in the discipline appeal, right? So if you're saying that whether, the merits of whether, for example, they're at maximum capacity, to the extent that we want to litigate over that, her right to attend Innovation Academy now, because or the all the issues related to the discipline now fall away, right? But
Right.
that is the claim that she's making here, is that it is the discipline, the illegal discipline decision is what gives her the right to attend Innovation Academy, right? And so that is the exact same claim that was raised before. Now, if she filed a petition, now, okay, first of all, I'm not conceding this is actually true. I'm just saying hypothetically, if there was a petition that said, we seek a writ of mandamus because the new reason that they have provided is wrong, well, that's a little bit of a different reason. That's not the claim here, right? The claim here is that SC's the illegal discipline itself and the reversal of that is what entitles her to the writ of mandamus. So, they're the master of the complaint. That is what they have asked for. And that claim arises out of the exact same claim that was raised in the previous discipline appeal. Does that make sense?
It does. Thank you very much for answering that question.
Okay. All right. And we'll go ahead and sort of wrap up this section of it. Res judicata is concerned with substance and not form. And so it doesn't matter that it was labeled a mandamus. This claim was labeled a mandamus petition now, and it was labeled something else before. It could not be labeled something else in the future, right? Like, we look at the substance. The substance of the claim is she was illegally disciplined, illegally barred, and we want her reinstated. That is the substance of it. You cannot, there's plenty of law that says you cannot just change the label on a claim and avoid res judicata that way. So that's one important thing to keep in mind. Another important thing to keep in mind is, right, the differences between res judicata and collateral estoppel. And collateral estoppel prevents the relitigation of issues that were actually decided in a previous case, right? Your Honor, you sort of alluded to this earlier, that res judicata, right, it applies to claims that were or could have been raised. So it does not matter that this court did not actually rule on SC's entitlement to return to Innovation Academy for res judicata purposes. And really, if you look at petitioner's response brief, their entire argument sort of stems out of that misunderstanding about the difference between res judicata and between res judicata and collateral estoppel. If you look at their header, says res judicata does not bar petitioner's writ of mandamus because the same issues were not capable of adjudication in the first case. And then the next subheader is the court did not adjudicate on the merits the issue. Well, I'm adjudicated on the merits whether SC was entitled to return to Innovation Academy. Right. That's under the assumption that the underlying premise there is that it matters whether a particular issue was decided or not, which it doesn't for res judicata.
Well, so right. one of the quotes that was, y'all lifted from from the prior hearing that we had, I said something like, I don't disagree with you that maybe it's outside my purview. It seems that the school board was arguing, at least in part, that I didn't have the authority in the context to order her to be returned to the school. Is your position that the reason I didn't have that authority was because no such request for that relief had been made in that case, in terms of formally in the form of a mandamus or other injunctive or equitable relief action?
Right. That it hadn't been properly placed before the court. Not that, it was raised, whether it was meritorious is completely different, right? For example, is it possible that it could have been, if that could have been raised before the state board? And then at that point, would it have been a claim that was able to be adjudicated through the appeal itself? Maybe. Could she have, instead of calling it an emergency motion for an order, could she have titled it a petition for mandamus? Of course she could have. Now, would it have been successful? I mean, we're not going to concede in the first one that she would have had a successful claim, right? I mean, and what we stated right in a brief, we don't think that that she would be able to show a clear legal right to relief here. But res judicata doesn't only apply to or res judicata doesn't only apply to meritorious claims, right? I mean, if the argument is we should not have raised that because because the statutory appeal, we did raise it. All right, we raised the claim. I mean, I'm speaking on behalf of, as if I'm the petitioners right now, as if I'm a SC. We did raise the claim, but darn it, we shouldn't have because the statutory appeal process said that we couldn't. Right? Uh, that is sort of a reconsideration of the or rewriting of the res judicata standard to say the res judicata does not bar claims that should not have been raised. And that's really what she's saying there. Of course, in the first appeal, we said, no, look, she doesn't have a right to. And we said over and over again that SC has not identified any authority that, or has not raised the claim properly and has not identified any authority for the court to do so. And that's true. They didn't, right?
Well, but I mean, forgive me, you guys know a lot more about, educational law than I do, but isn't that in part because this is a limited entry school or program as opposed to the the public schools? Typically, if you're just attending a regular public school and you get expelled from that program and then ultimately a court decides that you should not have been disciplined, you're zoned for that school, you return to that school. And here, the only unique aspect of it, it seems, is the fact that this is a limited entry program as opposed to a public school that's required by law to accept students that live in its district. And so are there other cases, are there other circumstances maybe associated with, private schools, although that's probably governed by contract and not by educational law, perhaps by other states that have similar systems to ours, but have magnet and, other type. I mean, that's what I'm struggling with, is that there would be no dispute and we'd be having no conversation except for the fact that Innovation Academy is a limited access program, which are, I think it's fair to say, relatively new animal in the state. And by relatively new, I don't mean like within a year, but
Yeah, you're right, Your Honor. That is sort of what makes this different. And again, that I think that I will definitely get to that issue more when we talk about the motion to dismiss side of things.
right.
But I also want to point out that that one of the reasons that we claim, that we objected to this court issuing any order that would require her to come back to Innovation Academy. Well, we said it right we said it in our pleadings that it was because the school was at maximum capacity, right? I mean, that issue, that defense was raised. And so that did come up the first time around too. But in any event, you're right that this is a little bit different. And, that does kind of, forget it. I'll just go ahead and segue right into the merits right now. I'm happy to go back to res judicata and talk about that more. But
let me say this. If
Yeah.
you have addressed to your satisfaction, understanding that you will get a chance to rebut the issues associated with your motion, then why don't I've been dragging you all over the place, some with valid reasons and some probably a little unfocused on my part, for a good nearly 45 minutes at this point. So why don't unless you have another matter that's associated directly with your motion.
Yes,
go ahead.
Your Honor. And I could go on for another hour and 45 minutes, but I get it that we all have other things to do. So so I will not do that. Now the motion to related. So it's a motion to dismiss / motion for summary judgment for a reason, Your Honor. The motion for summary judgment is really only applies to the res judicata issue. And that's because, right, this court is going to have to consider documents outside the pleading, outside the complaint in order to resolve it. And, Georgia Court of Appeals case law says, it's pretty clear that says that to the extent you have to consider court records outside of the pleadings to adjudicate a res judicata issue, it should be by summary judgment. But we moved to dismiss the mandamus claim on its face, right? And that is a much more straightforward that one doesn't really require consideration of documents outside the record. And so, just to be clear, we all know the petitioners bear the burden to prove that they have a clear legal right to the relief sought, right? In this case, they have a burden to prove that respondents have a clear legal duty to enroll SC at Innovation Academy, right? It's a tough burden. The Georgia Supreme Court, the Georgia Court of Appeals has said you pretty much have to point to on-point legal authority precedent showing the existence of that clear legal right or that clear legal duty. Or obviously, if a statute itself is clear enough, then I suppose there is a hypothetical situation where even in the absence of on-point case law, perhaps you could see a clear legal duty. But here the petitioners just haven't satisfied that burden at all, right? Like there is no on-point legal authority showing that SC is entitled to return to Innovation Academy simply because her discipline was reversed.
If it was just a regular, if it was, Alpharetta High School or Centennial High School or whatever the high schools are up in the north part of the county that I'm not familiar with, there would be no discussion of whether there was a duty, right? If the student lived in the district, the school absolutely had a duty to allow their enrollment, correct?
Yes, I think there's probably okay, I'll say this for hypothetical purposes, yes, probably that would be true. Now, it is true at the same time that that local school districts have wide discretion on determining what's in the best interest of students and assigning students. I hesitate to say that there would have been an absolute legal duty if she had been expelled from Alpharetta High School for her to return. She most likely, yes, she probably would have been entitled to return, but I'm not going to take a strong position on that because there are statutes that allow, in a local school district's discretion, for example, sending them to an alternative school if they think that that's in the best interest, or providing an alternative course of education that takes place at home rather than in the school. There's obviously school districts have exclusive control over the management of the schools and determining what's in the best interest of the pupils. So I would say that at minimum, the claim would be a lot stronger if it was just a regular school. All right, to your Honor's point. And I think you raise a good point on that. The United States Supreme Court in Goss basically said that once a state has decided that it's going to provide an education and require students to get an education, then it cannot, deprive someone of that public education without due process of law. Everyone agrees about that. There is no question that the Fulton County School District has a duty to provide a free and adequate public education for children that live within the school district. There's no question about that. All right, but that is also where the constitutional right ends. Right? It is not. I mean, everyone agrees that Goss does not create a right to attend the school of your choice. It's just a right to attend public school and a right to not be completely barred from public school without due process of law. The closest case that the petitioners cite on this topic is called, let's see, it's a really old case. It's a case, I believe, from 1937. Leals versus Landers. 184 GA 580. I'm going to let you, if you're going to plug that in, Your Honor, I'll wait to make sure that I didn't get that as a typo again here. But but that's the closest case that they cite, and they cite this case for the proposition that it is clearly established under Georgia law that mandamus is a proper remedy for illegal expulsion of a public school student. Now, in that case, Atlanta Public Schools again expelled the student from all public schools, not just one, and then said, but you're okay, you can go to this other school. No, they they expelled them from all of Atlanta Public Schools, so they're providing them no education. The Georgia Supreme Court in dicta said, all right, maybe a let's see. There is no question as to the propriety of the plaintiff's remedy being by mandamus if the petition otherwise sets forth a cause of action. I mean, in other words, what Leols said is that if the plaintiff proves their case, then they're entitled to a writ of mandamus. But in that case, of course, they ended up dismissing the claim on the merits. They found no constitutional violation or any other violation, and so they did not order Atlanta Public Schools to reinstate that claim. At best, or reinstate that student. At best, Leo stands for the proposition that a student that is completely expelled and is provided no education at all may have a remedy under mandamus to go back to that school. Now, granted, I don't know. Leols versus Landers was decided in 1937. That was a long time ago. And the fact that not a single petition for mandamus has been granted to sort of confirm whether Leols was correct about that sort of dicta that it was musing about is telling that it's been almost 100 years now. And as far as I can tell, there's never been a petition for writ of mandamus to reinstall them, and that's in this particular situation, and that's because the right to a free public education is not the right to attend any particular school. So mandamus has never been used to say, hey, look, even though you're getting a good education here, Alpharetta High School is a fine school. We're going to use petition for mandamus to say that you get to go to some other school. It's just never happened before. Now, and so I would say that is that's because there's no clear legal right for that to happen in the first place. That's why it's never happened. Now, what if the Georgia General Assembly said, hey, you do have a right to attend, if Georgia General Assembly specifically said that students shall have a right to go back to the exact same school that they were expelled from after, if their student discipline is overturned. Maybe mandamus would be available in that situation. But again, at that point, that would be because there's a clear legal right to it. That clear legal right or clear legal duty is a really high hurdle, and it requires something that's actually clearly on point. All of the public school choice statutes in Georgia are discretionary, or if they're either discretionary or they depend on factors that do not apply here. And so, the fact that they have not been able to appoint to either a case saying that, that a student gets to return to the exact same school where they started, or a statute saying that, shows that that right doesn't exist. They have a right to a public education. They do not have a right to go to a STEM school. And in the absence of that, this is where that whole discretionary thing is. There's a reason why the Georgia Constitution vests local school boards and local school districts with exclusive power to decide these kind of things. Why? Because there are a ton of factors involved. In fact, I'd even take the position that assignment of a student to a particular school is non-justiciable. It is something that is devoted to the local board's discretion entirely. And therefore, it's not something that, that in this scenario, when they are providing a actual good free public education to the petitioner, there is no clear legal right to relief here. And let's see. I just want to make sure that I haven't missed anything related to that. I know I've been talking forever. Everyone's probably tired of the sound of my voice at this point. Oh, okay. One last thing. It's really, I still am unclear exactly what the due process claim is here. I'll admit that. Due process requires notice and right? And there's no question that SC received notice in a hearing. And I'm just not seeing in the petition where she was denied that. So I'm just having a hard time understanding exactly what their procedural due process claim is because I don't really know how to respond to that. I mean, she was provided notice in a hearing. She has no constitutionally protected interest in attending any specific school. So I'm having a hard time understanding that. Last thing,
Okay.
they do say that, okay, forget about Goss. Let's look past Goss. There may be another source of this right, this right to attend Innovation Academy, and they claim that, and they argue that the Fulton County School District Code of Conduct creates a right to continue attending a particular school absent dismissal for cause. Right. That's how I interpret it. Obviously, Ms. Walden, she is going to correct me to the extent I get anything wrong on the way that I'm characterizing her claim. I'm just saying that's the way that I understand it. They're saying that the Fulton County Student Code of Conduct creates a property right in attending Innovation Academy. And they base this claim on an 11th Circuit decision, Barnes versus, I believe it's Valdosta State University, if I'm not mistaken. But in any event, what happened in the Barnes case, or Barnes versus Zakari, I'm sorry, Barnes versus Zakari, 669 F3D 1295. It's a 2012 11th Circuit case. In that case, the 11th Circuit Court of Appeals said, yes, you do the Valdosta State University's Code of Conduct created a property interest in continued enrollment at Valdosta State University absent for cause discipline, right? Agree. That is what that case says. Question is whether that case should be extended all the way to our situation. And of course, we would say no. Again, they were expelled from the student, the plaintiff in that was expelled from Valdosta State University. Valdosta State did not assign it to a different school. So it's not a very good analogy, right? Like he was out of school entirely. He wasn't just out of school and then attending, Valdosta's, for example, like one of Valdosta's extension campuses or something like that. He was expelled entirely. So the constitutionally protected interest was stronger in that case. It was the right to state education to begin with, and he was not being provided one at all. Second, obviously universities, second, the 11th Circuit specifically said, hey, look, by the way, this does not even create a property interest in attending college, by the way. We're just saying that specific to Valdosta State, based on their specific code of conduct, that there is a property interest in attending Valdosta State University. And that is very different from our situation here because Innovation Academy doesn't have its own special code of conduct. Fulton County School District has a code of conduct. That is the code of conduct that was used to punish her in the first place. So to the extent I do not agree that a student code of conduct creates any property interest whatsoever, but even if it did, it would only create a property interest in continuing to attend a Fulton County public school generally, not any particular Fulton County public school. It is a general code of conduct. Therefore, it applies generally. We will continue to provide you a free and adequate publication education absent good cause. So I do think that Barnes is not is not really analogous here. And for whatever it's worth, the Northern District of Alabama last year in the Ball versus Talladega County school system, In that case, it was, it was a factually different case, but what happened is that a school district closed down a school, and the students didn't want that school to be closed down. They wanted to continue attending that school. So they claimed that Barnes should be extended down to the K through 12 level, and saying that they have a continued right to attend that school. It's a constitutionally protected interest, that is protected by due process. And, I know it's only a district court opinion and it's unpublished even at that, but that court rejected that claim and said, no, Barnes is distinguishable here. Barnes, and what the court specifically said was, Barnes only recognized a constitutionally protected interest in a public education, and specifically said not in public education at any particular school. And that was sort of building on a long line of cases from the circuit courts, including the 11th Circuit, 10th Circuit, 8th Circuit, 6th Circuit. There's this long line of cases saying that, the Constitution does not protect or does not create a right to attend any particular school. They just have a right to a public education. And at that, I think I'm at about an hour, and I'm going to shut up unless you have any questions for me.
No, I think we've covered the waterfront. I'm gonna hear from Ms. Waldman. Before you do start, just give me 1 minute, please. Literally 1 minute. Thank you. Okay, less than 1 minute, but I'm happy to wait because I did say 1 minute. Ms. Waldman, whenever you are ready, ma'am.
I'm happy to go forward. Thank you, Your Honor. I will address these issues in the same order that Mr. Bryan addressed them, which is res judicata first, followed by the substantive right. What Mr. Bryan has conveniently left out of his perhaps 45 minutes on res judicata is the countless innumerable times that his co-counsel, Ms. Aiken, said the words, "Your Honor has the authority to remand, vacate, and reverse," and only those three things in the previous action. I think they spend hours on whether they had sovereign immunity on anything else. They spent every counter argument about reverse, vacate, remand. And quite honestly, I agreed with them, as did Your Honor, that was your authority. And that case was not the appropriate action. So there were two actions below. The first was my emergency motion. In the emergency motion, the only issue, right? Yes, I did ask for SC to be returned to Innovation Academy because there was a valid court order from the State Board of Education saying that the discipline had been reversed. Acting upon that state order, she had a right to go back to Innovation Academy. The district responded by saying, we have a stay. And we spent hours talking about whether the stay provision of the State and Superior and State Court Appellate Procedure Act applied to that hearing. Your Honor found it did, which meant she clearly had no right to go back to Innovation Academy at that point, and that issue was over, right? If the stay applied, there was no more Innovation Academy, it was off the table. So that raised it there was quite frankly irrelevant because I lost. The second matter was the case that came out of their appeal from 1160, 20-2-1160. There is, right, and again, we asked that as a natural course of action, SC be returned to Innovation Academy if we won. They said you can't do that. We had to, at that point, take them on good faith that if we won, the natural course of action would have gotten us there. Well, let's talk about the could you have done it. I will draw your attention, in this case, is not cited in our brief. It came about as a response to research, as a response to their reply that came late this afternoon, called Bacon v. Brewer, 196 Georgia App 130 from 1990. Bacon v. Brewer arises out of actions. It is a school-based appeal based upon hiring and firing of superintendents and teacher contracts. And I'll read to you the relevant paragraph from Bacon v. Brewer. The term local controversy refers to matters of controversy pertaining or existing within one local school board as discrete from other local school boards. The remedy provided by 20-21160 is the legal remedy for such controversies and is authorized in inception by Article 8, Section 5, paragraphs 1 and 2 of the Georgia Constitution, citing Patterson v. Boyd. The courts will not preempt this administrative remedy in the first instance, except as a matter of equity, where it is necessary to prevent irreparable injury or where equity alone can grant adequate relief. The courts of equity will not interfere until and unless the administrative remedy has been exhausted and has failed to eliminate the violation of law or the gross abuse of discretion, which is its equivalent, and this by way of appeal only. So that's precisely where we were in what Mr. Bryan has called SC1, right? Or SCV, Fulton County School District 1, right? We were at a place where we were at an appeal pursuant to 20-2-1160, where the school board was saying that the State Board of Education was incorrect. Your Honor found that the State Board of Education was not incorrect, reversed the Fulton County School District's decision, and then the state could have further appealed, they declined to, and then we had to continue to exhaust our administrative remedies to determine whether they would allow her to return to Innovation Academy. This is entirely different than the state's case of McCracken, right? McCracken was iterative appeals of the denial of a liquor license. This isn't iterative appeals because Your Honor issued a decision and she went through the process of applying to the school again. And in our, right, she never had to apply. She shouldn't have had to apply, right? The school, what happened after Your Honor's decision and is laid out quite lengthily in our reply brief, in our response brief, is that rather than take your decision, decide that their process was illegal and arbitrary and capricious, and therefore not process at all, and returned her to the seat that she was illegally removed from, she should have been replaced. Instead, what they did was they caused her to file an application, then they called it a transfer hearing, then they called it a bunch of other things, and at the end of the day, they ultimately said, denied waitlist. Unclear if it's a denial or a waitlist or if those are the same things, but denied waitlist. We don't know if it's a true denial on merits or facts. We don't know where she is on a waitlist, if there truly is a waitlist at all. We don't know actually whether they ever accept 11th graders because their immediate denial said, we don't accept incoming 11th. We don't accept 11th graders. We only accept 9th graders. This isn't an application case, right? Everything about Mr. Bryan's argument mischaracterizes this as a choice question when this isn't a choice question. This is a question about whether she gets to be replaced, returned to her rightful place at Innovation Academy. And the answer to that has got to be yes. If the answer to that is a no, why did we have a hearing in the first place? If the answer to that is no, what is the point of a due process? What is the point of a code of conduct? What they have done is benefited from their discipline over and over and over again without actually having a legal suspension in place ever. And that can't be, right, what the outcome of this is.
But
Right.
what about Mr. Bryan's point, though, that you're right, you lost on the emergency hearing. But theoretically, I think Mr. Bryan's argument is that nothing stopped you from filing or asserting count 2 of your initial petition. Well, I guess technically maybe it was the county and maybe that's the issue, but asserting a claim of some sort, maybe a counterclaim or whatever, that said she's entitled to be returned to the school. And your position is I couldn't have done that because she hadn't yet been refused to be returned?
That's correct, Your Honor. Right. So what I think Mr. Bryan is saying is that I was supposed to take it on assurances that they were going to act in bad faith. I think that's his argument, right? What he is asking me to have done was ask you in a separate litigation to counterclaim, naming not the district and the board because they have sovereign immunity, but naming all of the individual folks that we named in our mandamus, asking you for declaratory and injunctive relief for something they had not yet done, which is act in bad faith by not returning her to a rightful place. It was only, right, which would have been asking you for declaratory relief that I was not yet entitled to. That is in essence what he was asking you to do, right? When 20-21160, right, the Bacon case, and there are several others that I'd be happy to supplement with, right? When what they tell you is you're supposed to let the process play out. We let the process play out. I had every hope in the world that when the process played out, I emailed opposing counsel and said, now it's time to return her. And they gave me lots of hope that maybe that would happen. And there was no reason to believe that it would not happen, right? Mr. Bryan mentions many times that, right, maybe there'd be more cases. There's not more cases because it's self-evident, right? Maybe the reason why I can't find a case that says you get to come back to your school is because no school district has had the audacity to failure to let a student return to their school after they've lost their appeal. Maybe that's the reason that there are no cases since the 1930s, because it is self-evident upon its face that this is what is supposed to happen. If I could, Your Honor, and I don't honestly think I have more to say about res judicata. I'm happy to answer questions. Yeah.
No. Yeah. Then let me say this. I don't know that I need to hear more argument, but I do think in terms of the very helpful way that it was broken down by Mr. Bryan, right? When you look at the 3 elements, as I said, there's no dispute here that there was identity of party. I don't think there's any dispute that the court is a court of competent jurisdiction for any or all of the relief that was sought or is now being sought among and between the parties. And so the only real issue is, is the fact that the relief was mentioned and discussed, but perhaps not formally requested, does that count as having been asked for and adjudicated? I don't think it does. And so I think that the real issue is whether or not SC was required to assert that relief. And I think to put it in the same blocks, which is helpful to me that were laid out, your position is that there is not identity of claim for purposes of res judicata because there is SC could not have and certainly was not obligated to assert as a counterclaim this return to school relief because it wasn't yet ripe or because it required you to anticipate that the school wasn't going to comply with an order that said you wrongly disciplined someone. Is that roughly accurate?
That is accurate, Your Honor.
Okay.
Right. I think both of those. Right. And again, Mr. Bryan points out that I did not put a provision in the draft order with respect to this issue, right? Because they hammered home that this was not the appropriate forum, the appropriate vehicle, the
Well, and
appropriate
not just
turn.
that they did, but I know I said it
Right.
a couple of
Yeah,
times
you
during the
did.
hearing. And so in good faith, why would you try to put something in the order that I had expressly disavowed?
Exactly. That is precisely what was happening. I don't regret that I raised it. I don't, but in essence, 20-2-1160 was not the appropriate vehicle. There are the Bacon case precisely on point, but again, there are a couple of others that I'd be happy to provide. That sorry. Immediately preceding Bacon is a case called Bedingfield v. Parkerson, 212 Georgia 654. That is admittedly a 1956 case. That again talks about the fact that decisions of the Board of Education will not be interfered with by courts of equity unless they amount to a violation of law or a gross abuse of discretion. Right? What they tell us is we're supposed to let this process play out. And once, right, we appropriately agreed that this was not the right vehicle for it, we needed to let the process play out. And playing out the process was exhausting my administrative remedies through seeking re-enrollment at Innovation Academy. And it was only after that re-enrollment was denied, right? Not denied by the court, which Your Honor didn't do, but denied by the school district as a logical extension of the decision that we end up here. If I could quickly distinguish, Mr. Bryant talked a bit about the Supreme Court case of SG. SG does indeed have a footnote that talks about whether the student's record could be expunged, but doesn't actually decide the issue about whether the court got it right. That was not an issue in the Supreme Court at all. I will, as a side note that I wrote an amicus in SG. I have great familiarity with the underlying facts and circumstances of that case. It was decided there was a provision in the Superior Court case that ordered the clearing of her record. That decision was appealed through the Supreme Court and then by the Supreme Court remanded. And no decision was ultimately made. The Supreme Court didn't say, "Oh, the school district appealed the school discipline removal moment." It was just never contested in front of the Supreme Court. That was a kind of a dicta footnote to affirmatively identify the point, which is the decision's not moot, despite the fact that she had graduated. And so SG, I don't believe gets them where they are hoping to get with their footnote from a Superior Court. Just because a Superior Court judge had done it in the past doesn't mean they had the authority to do it.
Well, and
that wasn't an issue.
Well, and more to the point, that footnote might indicate that the party could have coupled those together, right, but it doesn't mean that the party had to do so. And if the party didn't have to do so, then res judicata doesn't necessarily preclude a later raising of the issue.
Exactly, Your Honor.
Okay.
And
if
then
you want to move on then to the main reason I asked you to clarify it in the framing that Mr. Bryant had offered is because it is helpful to me to think about it in elements and to talk about the way an order would go for me in ruling on that is there's no dispute about this. There's no dispute about this. This is where we focused our time and my ruling on this issue is X. So that's to make sure I understood.
I think my only slight caveat to, I guess, your framing was whether you were a court of competent jurisdiction, which again, yes, there is no dispute the Superior Court is a court of competent jurisdiction to provide, to give equity. But the question is, were you a court of competent jurisdiction in that proceeding to do so? And then as Your Honor had framed it, was it ripe? Right? Was I capable of providing, Your Honor, a cross claim for something that had not yet happened because they had not yet denied her entry, right? They had denied her entry because the discipline was pending, but they hadn't denied her entry after the discipline was finished. And the distinction between that and for instance, a damages claim, which I will note does require you to exhaust your remedies and does require you to go through mandamus first. So I will not concede that a damages claim is not still capable of being provided and perhaps, forthcoming. But the distinction there and what Mr. Bryan was identifying is that you get a remedy, right? There are things that are litigated, and it is not a natural consequence of winning a contract dispute how many dollars you get, right? And that is different here. It is a natural consequence of winning this discipline appeal that she gets to go back to the place that she was illegally removed from, such that there needed to be no full, in my right, it is our assertion that, right, which is the second half of this claim, such that there needed to be no counterclaim because that is just what happens. Whereas in further different remedies, they're not a natural consequence of that. And so it would make no sense to wait for the win before you litigate the rest of the issues. And with that, I am prepared to move to the clear legal right, unless there are
Okay.
Again, Mr. Bryan completely mischaracterizes this case as one of school choice. This is not a case about school choice. This is not a case about the unfettered access to the school of a child or parent's choosing. There is no doubt that had she not previously been a student at Innovation Academy, SC would not be entitled to automatically say, hey, Fulton County School District, please let me enroll in Innovation Academy. And not only please, but also you're required to. That's just not what this case is about. SC had previously applied to Innovation Academy. She had been accepted at Innovation Academy. She had been a student in good standing for 1.5 years at Innovation Academy. They ripped that away from her by illegally, arbitrarily, and capriciously suspending her. There is no doubt that the action of removing her from Innovation Academy was illegal. Your Honor told us so. State Board of Education also told us so. That has not been contested, and that is a final decision. So now what? Mr. Bryan would have us believe that that doesn't matter. And that what this case is about is that the school district has unfettered discretion to do whatever they want, whenever they want to. By their statement, as a student at Innovation Academy, SC could have done no wrong. The school district could have swept in and said, you know what? We don't like you anymore. We're going to send you to a whole different school. Not a school that, right, not for no reason, just because we want to, right? That is the essence of a violation of due process, right? Yes, they have discretion to do things, but they have discretion to do things lawfully. And they have discretion to do things within the confines of due process and within the confines of the Constitution, right? They couldn't just, if SC was at school at Innovation Academy and they decided, you know what, we're going to make this, we're going to decide that we don't like you because of your religion. We're going to remove you from school. That would be a violation of the Constitution and they can't do it. Same for saying we're going to remove you for disciplinary purposes, which is what they did. And we're going to do so in violation of due process illegally. That's where we are. This case is in fact not different at all than Barnes, right? Barnes is a case. Yes, it is a case about higher education. but that, again, choice schools are unique animals, and there's not a lot of litigation on this in their side or ours with respect to where that contract, right? So we have to look at the analysis, not at the name of the school. The analysis, right, which stems from Gus, which stems from Barnes, which stems
Well,
from
before you go
long-
too, forgive me
Yes.
for interrupting, Ms. Waldman. Before you go too far down that road, let me ask you this question, right? So I think what I heard, one issue that Mr. Bryan took with the argument about Barnes and the higher education issue is we're not talking about code of conduct that applies to the entire university system of Georgia. We're talking about a code of conduct or some sort of guidelines that apply to one school. Maybe it has satellites, but one school, Valdosta State or University of Georgia or Georgia Southern. And his point is that the code of conduct you're relying on by analogy from Barnes is the one that applies universally to all Fulton County schools, and that she's not been deprived or doesn't have maybe she has a property interest in attending a Fulton County school, but not this particular one. How do we address that issue when those cases are really looking at a particular code of conduct for a particular school?
So the property right that gets created is a property right that mandates due process. So again,
well,
if
that's
we're extending, right, if we're taking Mr. Bryan's argument, and then I'm going to come back directly, I promise. If we're extending Mr. Bryan's argument to its logical conclusion, they can take anyone at any time, at any place, and just pull them out.
Right. And I'm glad you said that,
school.
because I think that obviously I understand property interest doesn't mean
Right.
property interest. We all understand what it means constitutionally, but I agree with you that to me, it really seems like the framing of that issue is that the code of conduct guarantees some minimal due process before you are removed from the school. And of course, to Mr. Bryan's point, in the context of affirmed disciplinary action, right? Then yes, you clearly had notice and an opportunity to be heard. But in the absence of a valid affirmed disciplinary action, I think my understanding is your argument is call it a property interest, call it an expectancy that due process will be provided. But ultimately, your argument is that the code of conduct says or creates an expectation that due process will be abided by and that you will not be removed from the school without notice and an opportunity to be heard.
Exactly, Your Honor.
Okay.
Right, which is perhaps a conflation of the due process argument and the contract right argument. Right, they might be one and the same. They might.
I think they're two sides of the same coin, but
exactly. Which is that, right? It's not right. Mr. Bryan's saying that they can send anybody to any alternative school anytime they want. They can take anybody out of a high achieving school and stick them in a low achieving school. That's not what, right? The state, right? So let's get back to how does Barnes apply, right? The state has created in Barnes the policy manual, in the public school context, 20-2-754 et sec, right? The Public School Tribunal Act, which is the equivalent of the policy manual, which says we have a process when we want to remove you from a school. Now in Barnes, their explicit code might have been about Valdosta. It's honestly not terribly clear to me whether it's about Valdosta or about the university system Georgia in general. But let's go, right? We have a policy manual from the university system Georgia as it exists. Do we think that if you are a student at UGA, that the state university system can automatically say, you know what, we don't want you to go to UGA anymore. How about you go to Valdosta? I think everybody would agree that that is incorrect, inappropriate, and not allowed pursuant to due process, right? Yeah, they're all part of the state university system, but, we can't just pluck somebody out of the school that they've been in, that they applied to and got accepted at, and send them to a different one and say, hey, you know what? Georgia State's good enough for you too right now. because there is something special and unique about the school she applied to, right? And this might not be different if we were talking about Centennial versus Alpharetta, where there was no application. I think the very fact that there was an application created a greater private property interest than if there wasn't, right? I think the fact that this is a choice school makes it even all the more important that they not remove her from it, because she applied and got accepted, demonstrating the uniqueness and the specialness of the environment, right? The uniqueness and the specialness of applying to a school, UGA, and then getting that ripped out of you and saying, you know what, you get to go to Georgia State, it's just as okay, is not okay without process. Had she been legally suspended, absolutely, she gets to go to Alpharetta when she's done, right? Because there are procedures in place and there are rules in place that say after your suspension, you might not get to come back. But that's not, I will note that that's a rule they put in place after this case. But that's not, right? They get to make that rule, right? What the courts in Georgia, again, if we're looking at sort of the extension of Goss in Georgia, is a court of appeal case called DBV Clark, where, and I don't have a site for you because I'm doing this one off my education law teaching. DBV Clark is a case that says that we're allowed to permanently expel 12-year-olds. It's a terrible case. I won't want to wish you to actually expand it ever. But what it says is that if we create a system, right, that due process requires us to follow the system we've created. And once we have followed the system we created, that's all we're required to do, right? So DB essentially says our statutes, 720-2- whatever, allows us to permanently expel 12-year-olds. The court says it's a terrible statute. We should revisit it, but we haven't revisited it yet. And if our statute said you get to permanently expel somebody from a choice school, once they've been suspended from that choice school, they get to go to their discipline, that's okay. But only if that discipline is not illegal, right? They have to follow the Constitution first. They have to have a legal discipline before they get to remove somebody from the thing that is special that they let you come into, right? That's right. I think where Barnes takes us, and the fact that it's an application school, I think gets us the property right even more, right? It actually enhances the specialness of the school as compared to Alpharetta versus Centennial. I don't concede that they get to just willy-nilly move somebody, right? I think if they follow a process, I think if there's rezoning, right, we get to rezone. But if they just want to pick a kid out and pluck him out and move him somewhere, there has to be a reason. Your Honor hit the nail on the head, which is, what is your reason? Why are you doing this? Which perhaps gets to the third part of this, which is whether this is ripe for summary judgment, right? I believe they have clearly placed an issue in controversy, which is the reason. If they are relying upon capacity as a defense, then we must litigate the issue of whether they are indeed at capacity. Now, I don't believe capacity is a defense. Perhaps Mr. Bryan is willing to concede that it is not a defense and that they don't need to go there. But, right, to the extent that that is their defense, that is their why, that is their just cause, that is a fact that is in dispute. I am happy to answer further questions, but I feel as though, right, I feel as though these issues are less complicated than Mr. Bryan does, and we'll stand on the brief for the rest, absent questions.
Okay, I do have one question, which is, and I think you've answered it, but I just need you to frame it to make sure I'm processing it properly, which is, as to the motion to dismiss, right? I know we spent a good deal of time talking. So the basis that Mr. Bryan has asserted to dismiss this mandamus action is that there has to be a clear legal right, the inverse of which is that the entity that you are seeking to force to act must have a legal duty to act. And I think I understand you saying that if nothing else, the legal duty arises from either a property interest or a requirement for due process to apply. Is there another area or aspect that you were pointing to as to what duty the school would have?
I think it all comes property interest, right? There is, I won't lie, the interest of justice argument, right? There is the argument that says that when the government acts in an arbitrary and capricious manner, mandamus is appropriate as a legal remedy to perfect a defect in justice, right? That is admittedly our third argument. I believe that the clear legal right comes from a due process property contract relationship that mandates that the only way they could have removed her from Innovation Academy is via legal process, right? Not illegal, right? Yes, she got a lot of process, but it was deemed to be illegal as a removal, which automatically reverts us to the status quo ante, right? She must be placed back in the position before they acted illegally. If
Thank you,
not,
Ms.
I
Waldman.
don't know why we have, I mean, honestly, if that is not a true statement, I don't know why I bother going to hearings ever. I mean, I'm not even like, I know, like, I don't know why we have, right? We can just take 20-2-754 and rip it out of the code book. The legislature knows how to do that, but they chose process as a predicate for removal. And having done so, they don't get to remove without legal process.
Thank you, Ms. Waldman. I appreciate it. Mr. Bryan, you get to respond, sir.
I appreciate that, and I'll go ahead and pick up right where you left off about what the legislature knows how to do. Legislature knows how to create rights. They know how to create process. They know how to create duties. They haven't in this case. All of these arguments have been, you know what? We gotta fill in the gaps ourselves. It's our job as litigants, and this court's job as a superior court is to fill in the gaps that the General Assembly has left and do it in a way that favors my client. But that is the exact opposite of what the burden on mandamus is. The exact opposite. Burden on mandamus is you have to show that the General Assembly, the legislature, was clear about it. Any ambiguity in the law inures to my client's favor because the Constitution vests them with discretion, right? So that is the whole point of the clear legal duty requirement, is that where the legislature hasn't addressed it, where the courts haven't specifically addressed it, they have discretion to do it. And I would say the fact that the legislature, and we know the legislature knows how to do this kind of thing. I mean, in OCGA 22-2131, it says a student who transfers to another school pursuant to this subsection may, at his or her election, continue to attend such school until the student completes all grades of the school, right? I mean, the legislature knows how to create some sort of, right to attend a school because it did in there. Of course, that statute doesn't apply to Innovation Academy. Innovation Academy is specifically exempted from that statute, but just the fact that the legislature has created a right to continue attending such schools in certain situations suggests it knows how to do so. And it hasn't done it here. And they have not satisfied their burden to show a clear legal right to relief here. That is a high burden. They have not satisfied it. One housekeeping note on that: we did not move for summary judgment on the on the clear legal right to relief or clear legal duty issue. We moved to dismiss on that, right? Because we did not introduce any evidence relevant to that issue. Okay, so that's specifically why we said motion to dismiss versus motion for summary
Right.
judgment.
I understand that.
Yeah.
I mean, what I understood, the only issue I understood Ms. Waldman to raise on the motion for summary judgment in that regard was that there is a disputed fact issue as to what was the basis for declining to allow her admission and what are the merits of that stated basis.
Right.
And that has, I understand it to do, at least to my way of thinking, that has to do with with the summary judgment motion, not the motion to dismiss.
No. The motion for summary judgment only has to do with the res judicata issue, because that's the only issue that requires this court to consider documents outside the record, right? And that's what. Sorry.
Well, I mean, I understand your point, but on a summary, I mean, the reason I asked you the question about what was the basis for the denial of replacement or admission of SC was during the portion of your argument about res judicata and about the identity of the claim. And how can I understand and assess whether the claims were in fact identical or not identical? I had identity with one another and or should have been raised in the prior action unless I have facts before me that have been either undisputed or determined by a fact finder as to the basis for the dismissal. That's what I understood.
Okay.
And that's what I was asking you at the time.
Yeah. Fair enough, Your Honor. Okay, so they attached, I mean, just to be clear, they attached the rejection letter to their pleading. So that is part of the pleadings. So the court doesn't need to go outside of the pleadings for summary judgment purposes in order to consider that. I'm sorry. I know this is like super highly technical. Like I get really in the weeds about this procedural stuff. Probably would have been easier to say, oh, it's all summary judgment. But I just mean that because they attached it to their pleading under the rules of law, that can be considered as part of a motion to dismiss, and it doesn't need to be raised as a motion for summary judgment. You see what I'm saying? Because then it becomes a written instrument attached to the pleadings and therefore can be considered a motion to dismiss. I said that whereas the res judicata thing, she didn't attach all the documents from the previous case to her pleading, so we had to go outside the pleadings. But the rejection letter is in the pleadings, so that's why it doesn't require summary judgment there. But anyway, sorry. Getting off of that, I was a little sidetrack procedural issue here. I just wanted to clarify my position on that. Would like to go back to some of the res judicata arguments that she raised. And I mean, look, honestly, the way that Miss Waldman remembers what happened in the first case is very different than the way that I remember it, and very different than the way the transcript is. Can I share my screen real quick?
Sure.
All right. All right, can you see that on your screen, Your Honor?
I can.
All right, so this is right. This is just a little excerpt of the transcript. What Miss Waldman said, how was I to know that the Fulton County School District wasn't going to admit SC back to Innovation Academy until after that case was over? How was she going to know that? Was I supposed to assume that Fulton County School District was going to operate in bad faith? Paraphrasing, but generally that was the argument. This is her argument right here during oral argument. The school district appears to be telling us that they don't care if they lose, because if they lose, they have no intention of putting SC back to her rightful place at Innovation Academy. No one is surprised. Not us, not Miss Waldman. No one should be surprised that was the position the Fulton County School District took. That's the position that we took during the litigation. That's the position that we litigated about a lot, was whether we were right to say that or whether Ms. Waldman was right to say that, you should order her to go back. So the idea that, holy cow, how was was supposed to know this was going to happen is just, it's just, it's a post hoc rationalization now to avoid res judicata, but we know that that's not actually true. Everyone knew what was going on. Everyone knew what was happening. We litigated over whether she was allowed to return or not. This court ultimately decided not to include that. Now, you didn't say in your order that I didn't have jurisdiction to do that. You didn't say that this is something that I'm not authorized to do. You're just silent on it, right?
But I don't think, but I agree with you in the order, but I don't think I was silent in the hearing. I know at least once I said, I believe that's outside my purview. And in fact, I think the way I said it was, I agree with the school district that that's probably outside my purview. And I think I referenced it at least one other time when I was talking about the relief that I was or was not going to grant. And then ultimately, Ms. Waldman submitted a proposed order that aligned with what the ruling was going to be, which was that I was affirming the state board.
You're absolutely right about all that, Your Honor. And this is here. This is what we put in our brief right here. That exact. I don't necessarily disagree with you. That's something that's outside of my purview. We're not running from that. It's right there. It is literally on the next page of our brief. We understand that the issue of whether you had, or the claim and the issue was raised of whether you had authority to do that in the first place. We took the position that under the case as it was presented by, by SC, that they had not identified authority that would allow you to do so. And they hadn't, that was the point, is that they hadn't. They just asked you to do it, but they didn't cite a statute saying that showed you giving authority. They didn't cite a waiver of sovereign immunity. Of course, we're going to point out the problems in their request, but that doesn't mean that they didn't make the request, right? Now, let's just remove the label on their emergency motion. Let's just say that instead of emergency motion, it said counterclaim. All right. All we do is change the label. Would that change how res judicata applies? Because if it shouldn't, right? The label on a document has absolutely nothing to do with whether res judicata applies to it, because we look to the facts, we look to the wrong, we look to the, we look to the allegations, we look to the claim. We don't look to the label of the, whether it said motion for emergency hearing or petition for mandamus or petition for equitable relief or motion for equitable relief, right? Like that's all just form. Res judicata is not concerned with form at all. It's concerned with substance. What did they ask for? What did they allege had been done wrong? What are the facts supporting it? All of those things together are the same facts, the same alleged wrong, and even the same relief, just with a different name on it, that they're asking for in the second one.
What about Ms. Waldman's assertion? I think she relies on, is it the Bacon case, maybe? Yeah. For this argument that she had to exhaust administrative remedies by seeking reinstatement and being rejected from that reinstatement before this cause of action would be right.
Okay, so she did seek that relief. She did seek that relief when she asked this court for it. That is exhausting that administrative remedy, is that it was part of a statutory appeal process, and she asked for it through that process. Now, whether she did it properly or not is a completely different question. Res judicata is not concerned with whether whether it was raised properly. It's just whether it was raised. And I did want to mention something. I completely agree with you, Your Honor, about how you're breaking all these down and putting things into buckets. Completely agree. One part of your colloquy with Ms. Waldman, I do disagree with, though. And that is when, you two were talking about the SG case. And you said, well, obvious SG shows that a claim outside of, what's mentioned in the statute can be raised, then a claim for expungement, even though, the appeal statute doesn't say anything about expungement, they still could raise it. And then you said, but that doesn't mean that they had to. But that's not res judicata law, Your Honor. It's res judicata bars claims that were raised or could have been raised. Either or both in this situation. But SC did raise this claim. They didn't label it a mandamus claim. They labeled it something else. But they did raise this claim. They obviously could have raised the claim because they did. And so the fact that they weren't required to raise it, that is not relevant to the res judicata analysis. It's whether it was raised or could have been raised. Why? Because res judicata is concerned with the finality of litigation. It's time to put an end to these things. All right. So once someone raises claims for relief in an action, that's it. They get one shot at it. If they don't get it, if they don't get the relief sought, they can ask for reconsideration. They can appeal and say, we're appealing the implicit denial of our claim for reinstatement, right? And the failure to do so precludes them from raising it again. As far as due process goes, they received due process. They received so much process. They received how many hearings? Let's see. 1, 2, 3, at least 4, 5 hearings, 2 in Superior Court, 1 before the state board, 1 before the local board, 1 before a hearing officer. I mean, there's 5 hearings there. They had plenty of opportunities to raise their claim that she was entitled.
But one could argue that the reason she had so much due process is because the state board the school district just kept refusing to do after the district level hearing, just refused to do what the state board told it to do. And then, you're right. There was a lot of process, but that process was associated with the discipline. And now that the discipline is gone, the student asked to be returned to the position she was in, and the school, ultimately what I have to determine is whether or not that request to be readmitted could have been raised or should have been raised such that they were required to raise it and in failing to do so would have been barred by res judicata or collateral estoppel. And that's why I was asking you guys to try and put it in these buckets for me, because it keeps coming back to identity of claim for me. And I think I've already said, and so I'll just say it again, I don't think that the request in the emergency order or the informal statement that would be relief that they would like qualifies, that creates an identity of claim. So the real question, or that it means that they formally requested it. So then the real issue is, if they didn't formally request it, were they required to request it? Because it was a compulsory counterclaim or associated in that way. And that's really what I'm trying. To me, that's why I argued with you, Mr. Bryan, when we went back to this issue of if there's a dispute of fact as the basis for declining to allow her admission. And you are right. If the letter itself is attached, right, then that would not mean, that would make it allowed to be considered by the court, not necessarily on a motion for summary judgment from a procedural perspective, because it was attached to a pleading and therefore is before the court appropriately. But what I keep coming back to is, and that's why I asked you about it originally, is isn't the reason that the school turned her down, the stated reason or the subtext reason or the process to which they put her for her effort at reinstatement at the school, isn't that an issue of fact that has to be resolved by the court to determine whether or not res judicata applies?
No, Your Honor. It doesn't. In order to determine maybe the merits of that, potentially, but not for res judicata purposes. Res judicata purposes looks at is only considered by, you look at the pleadings and you look at the requested relief. That's it. The res judicata issue is determined solely by looking at court documents from a previous case to see if the cause of action is the same or the claims are the same. And you don't have to look outside of any of that because we can look at what the claims are by looking at the petition, right? And we can look at the set of facts giving rise to it by looking at the petition. We do not have to look outside the petition to see whether these two cases are the same claims. In fact, I've never heard of a res judicata defense that required a fact-finding mission about exactly what was raised, and whether that constituted the same claim as what was raised in a second suit, because to determine what the cause of action is for this claim, you look at the pleading. And to determine what the cause of action was for the previous one, obviously you look at the pleadings there, and you look at what was raised in the hearings and all that. But no, we don't have to go into that. For now, it is enough that we know from the allegations in the complaint what their claim is, and we know we can decide just from that whether it's the same claim as that was raised before. And obviously, of course, it's our position that it is the same claim. And, especially to the extent that it arises out of the supposed or the disciplinary decision and any right that she thinks that she has to return to Innovation Academy due to her successful appeal, because all that was raised in the initial appeal.
Understood, Mr. Bryan. Okay. I appreciate the time that y'all have spent. I appreciate your answering what may have seemed some of my unfocused or a little bit off the wall questions, but I do appreciate you walking me through those. As I've said a couple of times, to me, it comes down to this identity of claim issue. And what I think I've made clear that I'm struggling with is that I'm not sure I agree with you, Mr. Bryan, that this is, that the request to be reinstated after her discipline was fully removed is in fact the same claim, even if the relief that they mentioned associated with their appeal was the same relief. I'm not sure I agree with you with the mandamus defendants here that the request to be returned to the school or admitted to the school is exactly the same claim in these circumstances. And so I don't think that res judicata bars this action. And also, I think that while I agree with you that Ms. Waldman will maybe have some work to do to establish what that legal duty is for purposes of litigating the mandamus action on its merits, I don't think that it's subject to dismissal, given the at least facial argument that the student has made that due process notions and potentially a property right could rise to the level of establishing a legal duty that the school is required, the school district or the school members are required to comply with. And so all of that is a long way of saying I'm going to deny the motion to dismiss. I'm going to deny the motion for summary judgment. And then I'm going to ask Ms. Waldman to present me with an order, please, a proposed order that I can review. And then my next question is when, where, and how will the parties be prepared to have a full hearing on the merits, on the mandamus action? How do we expect that to be presented and how long do we think it will take? Ms. Waldman.
Sorry, my mute button wouldn't work. I honestly do think there are some fact issues to investigate. As we go through this, I don't think a long amount of time. I will note that Emory is closed next week for spring break. So I am finally taking some days off because
I'm sure they're well earned.
I mean, honestly, I think 30 days is probably sufficient. I at this point in time, it is no longer practical to believe that SC will return this school year. I believe we are looking at a return to school for the fall at this point, just based on time. I have put that out there to the district several times as a timeliness once this action got set. And so I think we are in maybe a little bit of a less of a rush, although we would like finality. For real, we would like finality. So I guess that was a long-winded way of saying I think 30 days is perhaps enough, but I will defer to the court and wouldn't oppose a little bit longer.
Mr. Bryan?
Well, I'd love to. Unfortunately, me and Ms. Akins are not in the same room right now, and I don't want to. I prefer to be able to. Is there any way that we could chat about that and email?
Yeah, if y'all want to think about it, I mean, I'm really asking a larger question, which is how is it that you anticipate the evidence will come in on a mandamus hearing? Are you expecting to make proffers? Are you expecting to offer witnesses? Will this be primarily legal argument? How long do you think it will take? Like, as in, do you think it will take 2 days? Do you think it will take 8 days? Don't say 8 days because there's no way this takes 8 days. But that's really my question, because that will inform me more about the amount of time the court should give the parties to get their ducks in a row and have their evidence ready to present. Ms. Waldman, what does this hearing look like for you, and how long does it take?
I honestly think this is largely a question of law. I do think there are some small factual issues, but I do not think this hearing will take more than a day. I would be surprised if this hearing takes more than half a day.
Okay.
But this particular legal argument has already taken 2 hours, so.
Yeah, I know. Fair enough. Okay. And do you agree generally, Mr. Bryan, that this is legal issue and to the extent factual matters are in, it's not going to drive the train, and that maybe a day is sufficient, and that maybe, looking at setting a 1-day hearing sometime in the next 2 months, that y'all could figure that out? What are your thoughts, Mr. Bryan?
Yeah, I agree that this is primarily legal issues, which of course is
why you filed your motion.
But to the extent that there is a factual issue, I cannot really see it. I don't really see that taking long. I mean, I guess first of all, I don't even know if we would. I mean, I'm spitballing, thinking out loud right now. I mean, it's probably the case that it's, they're probably going to put one witness on the stand, maybe 2. And in that case, if all the facts that are necessary come out like that, then I mean, the evidentiary part of it should probably be pretty quick, I would think.
Here's what I'm asking, and I'm not going to lock you down to anything right now, but I'm just throwing out the fact that if we're talking about 1 day, depending on my trial schedule, I have I'm presiding. I could do April the 18th, which is a Friday. And I could do April the 25th, which is also a Friday. I may be able to find other days in there to fit it in, depending on my criminal trial schedule. But at the end of the day, that's sort of realistically looking at my calendar and with spring break coming up for my kids and all that good stuff, right? That's sort of what I'm looking at. If I were to put it out at that point, it's only March the 6th. That would give y'all plenty of time. Ms. Waldman mentioned 30 days, but wouldn't be opposed to more. I'm not saying it will definitely be one of those 2 dates, or that it will, I'm not saying which one or the other, but that would be the likely timeline. why don't we do this? Given that likely timeline, why don't y'all have a chance to roundtable it, and then perhaps y'all just jointly email me and say, we'll take one of those Fridays, Judge, and we'll get it on the schedule and notice it for you.
Yeah, that's totally fine. Yeah, April 18th or April 25th. I don't see a problem with that.
Okay,
I
Ms.
have
Waldman?
I have a preference for the 18th if those are the 2 days that are out there. But I will rework some things to make the 25th work if necessary.
Yeah, no, I mean, 18th is fine with me if that's, I mean, I guess at this point, we'll just say the only caveat would be if Mr. Bryan or Ms. Aiken says, no, that date definitely won't work, and then we'll come up with something else. My only limitation that day is I'm a drug court judge and I have a graduation that day. So I have people that are actually graduating from drug court. Yay. And so I would need, if it went on, I would need to take a break at around 1:30 to go do that. And I'd be back at around 2:30, but I'm certain we could accommodate that. So, okay.
Yeah, thank you, Your Honor. Ashley, does that work for you?
Yeah, I was just going to point out April 18th is Good Friday.
Oh,
Now,
Completely frank, I had planned on taking the day to do some family activities that can certainly be rearranged, but it is Good Friday right before Easter.
yeah. The reason I hadn't marked it as such is for some reason my kids' high school scheduled prom that weekend. So it pretty much ruined all my Easter plans, but
and I'm
Okay.
Jewish.
Yeah.
I was looking for Passover.
oh goodness. Okay.
It is
Yeah.
not Passover. It is the 4th day of Passover, according to my
Interesting.
calendar.
Okay. Well, we have some room to maneuver, but the idea is that it will be sometime in the month of April. If we can even push it later, but then we start to get into May. I just don't want to be, I want to, as Ms. Waldman said, there is a little bit of room, but once we start getting into May and then I'm going to give you a final decision and then somebody might appeal it. And so, we do start actually running into whatever the decision is. Does the child know where they're going to be attending school when school starts in August of 2025? So for their senior year of high school. So,
That is
Okay.
definitely a concern for us. And if I can make the 25th work, just as a note, if necessary.
We'll touch base.
okay. Yeah. Y'all do that and let me know. I probably will have prom things to do for April the 18th. So if that's not a date that anybody wants to work, that's fine too. As I said, given that it is just lawyers, we could do it in person, we can do it by Zoom. I have a good bit of freedom. And so if the 18th or the 25th are not days that y'all can make work, then throw out some other days that y'all can make work and we'll see what we can do. Okay.
Understood.
Okay.
Thank you,
Thank
Honor.
you all very much. Have a good day.
And do you have a time frame for a draft?
I'd
order?
prefer before you go out of town, but but that's a real short turnaround
I
time.
go out of town tomorrow at 8 a.m.
Well, then probably it won't be then.
That's why I was asking.
A reasonable amount of time. I mean, if
Um,
you're going out of town for spring break next week, if you can get it to me the week after that.
That would be great, Your Honor. I
Yeah,
appreciate
that'll be
it
fine.
because I
No
do
problem.
leave it at 8 a.m.
Okay, excellent.
Thank you.
Well, enjoy your holiday.